Thank you very much, Magdalena, and hi, everybody. Thanks for the very kind invitation for this discussion. It's very nice to see many familiar names, albeit not faces, but you can hopefully see me and hear me properly. I'll try not to talk too much and to cover a very peculiar set of third country relations when it comes to the EU's overall management of asylum and migration, which I think we're all no stranger to. The Greek-Turkey relations, especially in 2020, the impact of the so-called border crisis unfolding in Evros at the beginning of March 2020, the ensuing effects of the COVID-19 pandemic, and the overall effects on the EU-Turkey statement or deal that we'll discuss in more detail. This we could try to do in three main blocks or tenets. First of all, the immediate reaction from the Greek government to the events of Evros in March that culminated in the suspension of access to the asylum procedure for 1 month under an emergency decree. Secondly, the more specific consequences arising from the COVID pandemic in terms of EU-Turkey relations. And finally, a more forward-looking element, because we're all following on from yesterday's conversation, looking at yet another round of reforms of the Common European Asylum System, the implications for the new Pact on Migration and Asylum, and the legislative work to come. Starting very briefly with why and how Greece decided to suspend access to its asylum system for 1 month. As you may remember, at the very end of February 2020, Turkey announced that it would no longer prevent refugees and migrants from coming to Europe via the Greek border. And this resulted in a number of people arriving at the land border of Evros between Greece and Turkey. The response from the Greek government was to pass an emergency decree, which is called an act of legislative content in Greek terminology, that would allow Greece to refuse to register asylum applications for 1 month and return people without registration to their country of provenance or country of origin. Interestingly, the political discussion that surrounded that decision at the time reminds us a lot of the issues that Markela touched upon earlier this morning when it comes to the European Court of Human Rights ruling in NDNT. There was quite a bit of quoting or misquoting, if I might add, of the NDNT judgment of the court and what it actually allowed member states to do when faced with arrivals of people at the land borders. It was seen, especially in political circles, as a judgment that would enable Greece to respond to the type of situation of large numbers of people arriving at the land border by refusing to register their claims and proceed with immediate deportations. In more practical terms, what happened was as follows. And there, the situation affects both Evros and the Greek islands for arrivals by sea. People who arrived on Greek territory during that month, March 2020, when the decree was in effect, were served automatically deportation and detention orders to be readmitted to Turkey. Crucial to add that this was also the case for Turkish nationals who were thereby to be returned to their country of origin without any assessment whatsoever of risks of refoulement, of the fact that an asylum application was made, etc. An additional factor that is quite important in terms of the legal implications for the international refugee regime is the fact that criminal charges for irregular entry were also pressed against individuals that entered during that month. These are cases that are now in the process of being challenged. And of course, again, there was no consideration whatsoever of Article 31 of the Refugee Convention and the reasons why refugees should or should not be penalized for irregular entry. The decree was in force and in effect for 1 month, which means that following the end of March 2020, people who were in Greece, as we will be discussing, no one was returned, should have prompt access to the procedure, should be able to, let's say, reactivate and continue their engagement with the asylum process. In very practical terms, given a wide array of obstacles to prompt registration of asylum claims that we can discuss in more detail if of interest, people have not had immediate and prompt access to the asylum procedure even after the effects of the decree wore off. Coming in with more of a legal, let's say, perspective, to try to tie this also to previous discussions, one thing that from our side was particularly interesting, if very worrying, was the way in which domestic courts at the Greek level interpreted the legal status of the decree and its actual effect on Greece's international law obligations when it comes to refugee protection. As was discussed by a number of stakeholders at that point, including UNHCR, neither international refugee law nor the Common European Asylum System allow for any suspension of access to asylum, even in situations that, according to Greece, were characterized as a so-called asymmetrical threat against the country. So it's quite clear that from the point of view of EU law and international law, this was not something that was permissible. That being said, the reading that was adopted by domestic courts, and this is specifically the Administrative Court of Athens. I realize I haven't included the references of the decisions, but this is a number of decisions ranging from decision 356/2020 to decision 360/2020. All those delivered in early April 2020. In those cases that concerned judicial review against detention of people who were caught in that effect of the decree, the court stated, as cited in the unofficial translation, that the decree responded to an asymmetrical threat to the security of the country, which supersedes the underlying international and EU law rules on the asylum procedure. Court also referred to the fact that if people were to be allowed to access the asylum process, there would be substantial burden on asylum authorities to register their claims, which of course is kind of the case anyway when it comes to Greece for the past many years. That reading is particularly striking in the sense that domestic courts seem to admit that what is identified as an asymmetrical threat to the security of the country, without necessarily an explanation of why this is a security threat, justifies not applying fundamental and non-derogable rules. As you can imagine, given this interpretation, the court fully disregarded the fact that the people had made an asylum application, so they had expressed the intention to seek asylum. It treated those cases as pre-deportation detention. So detention was upheld by the court on the basis of a risk of absconding of the individuals that was established inter alia based on the fact that they entered during an extraordinarily urgent and unforeseeable situation for the Greek state. And as we will discuss in a bit more detail in a bit, the court also failed to assess whether the reasonable prospect of removal or a realistic prospect of removal to Turkey was established in those cases, which means that in practice, detention was upheld, deference was paid to the decision of the Greek government to suspend. Now, come mid-March 2020, even before the end of effect of the decree, Greece, along with the rest of the world, takes measures to respond to the rising COVID pandemic. This included a number of measures, such as suspension of operation of the asylum service, a restriction on freedom of movement imposed on the camps of the islands, and also a number of other reception facilities. But for the purposes of our discussion, what is very interesting is the fact that since the 5th of March 2020, so temporarily quite close to the events of Evros, the Turkish side communicates to the Greek authorities, its counterparts, that readmissions under the EU-Turkey deal will not be taking place due to COVID. To our understanding and knowledge, this suspension is still in full effect. There has not been a single readmission under the EU-Turkey deal since March, so that's more than 6 months since that suspension. And per the latest Turkey report of the European Commission that was published earlier this month as part of the enlargement process, there are interesting passages that you can find, specifically in pages 48 to 49, where the European Commission confirms, on the one hand, that Turkey is not accepting readmissions under the EU-Turkey deal, and on the other hand, that the bilateral readmission agreement between Greece and Turkey remains suspended. The suspension was announced in 2018 by the Turkish side. And the EU-Turkey readmission agreement continues not to be applied by Turkey when it comes to third country nationals. As you might recall, this was a very strong political point where the Turkish side was resisting and still resists the application of that readmission agreement to non-nationals. Now, as a small pause and perhaps a trip down memory lane, if we go back to about 4 years ago, including an ERA conference on European asylum law back in October 2016 in Trier, the European Union was very clearly of the view that the EU-Turkey statement, as it's called, is a declaration, a political statement that produces absolutely no legal effects on Greece or the rest of the EU. As you might also recall, this was also the position that was maintained by the European Council, the Commission, and the Council in judicial proceedings before the General Court, to state that the EU-Turkey statement is not an international agreement and is not legally binding. The view then of the EU institutions, as explained back in 2016, was that since the EU-Turkey deal is only a political framework, not a legal act, readmissions to Turkey can only happen through legally binding acts, meaning either bilateral readmission or EU readmission agreements. Problem is, both of those are suspended. They've been suspended for quite a while now. So there's actually no clear legal basis on how to return people to Turkey, even though returns under the EU-Turkey statement continued up until a point. And the latest Turkey report of the European Commission seems to distinguish those two categories. It first states that Turkey deal suspensions have been stopped by Turkey, and then moves on to say that the readmission agreements continue to be suspended. Now, this might imply that the Commission seems to revisit its own position by, let's say, alluding to possible legal effects of the EU-Turkey deal. That could be an open question and something for us to discuss. Coming maybe back to current reality and to the position of the Greek administration and the Greek courts, the fact that readmissions are in complete suspension, there is no basis whatsoever to realistically push for people to be returned to Turkey, should have been something that is taken into consideration by authorities when ordering detention. As we all recall, a reasonable prospect of removal is a prerequisite to pre-deportation detention. And of course, also on courts that are charged with judicial review of the legality of detention orders. Unfortunately, none of these things have happened in practice. So we continue to see decisions issued not only in April, also later in the summer, in July, where the administrative courts uphold detention orders, even though there is absolutely no reasonable prospect of persons returning to Turkey. I would also add that a discussion that has unfolded positively in many European countries around the impact of COVID per se on detention, with also very strong statements from UNHCR, interesting judgments from a number of countries releasing people from detention given the risks of contracting COVID in detention centers, has not really been a debate in Greece. So any efforts to bring to the attention of the court the fact that people would face very potent health risks in detention, given the lack of preparedness to deal with COVID, have been dismissed as unsubstantiated and abstract allegations that have no basis. Now on to the final parts. Why is any of this relevant to the EU level and to the discussions on the reform of the Common European Asylum System? I would say there are three main aspects that merit consideration. The first, which probably goes a little bit beyond the scope of our discussion, is the impact of the very tense political situation and the blocks, let's say, on implementing returns, on intensification of pushbacks. As we know, this is a practice that is neither new nor unknown in the Greek context, but has definitely intensified over the last months, especially when it comes to the conduct of the Hellenic Coast Guard in pushbacks at sea. What is also quite striking is the significant degree of complacency on the part of EU institutions, namely the European Commission, despite strong calls from the European Parliament on the Greek authorities to provide information to explain why a high number of allegations are emerging, including from IOM, from UNHCR, from different bodies. And of course, the broader rule of law considerations and implications when it comes to complacency. So inaction on the part of the EU institution that is the guardian of the treaties and the main enforcer of EU legislation allows member states to act beyond the remit of their obligations, and crucially to treat watchdogs, civil society, also media, reputable international media, as non-credible sources of information. This is very much what has been going on in Greece for the past months, with a wide array of evidence being discredited. Second aspect relates to the institutional responsibility of the EU when it comes to arrangements with third countries. The EU-Turkey deal was a very substantial political investment on the part of the European Union, a very controversial one, a very highly criticized one, but one that continues to be the blueprint for the overall management of the EU's asylum policy. The EU continues to present the EU-Turkey deal as a success in managing refugee and migration flows. What are some of the main problems that we continue to see? As we just talked about, the legal basis and implications of that deal are still not clarified. Might I add, they would be less clear now than what they have been before, given the implicit abandonment of the view that the Turkey deal is not a deal. Secondly, and quite interestingly, there is no credible monitoring at the EU level of conditions facing people returning to Turkey, even in the face of mounting evidence of increasing restrictions on refugees in Turkey when it comes to access and registration, when it comes to protection from refoulement, when it comes to living conditions that would have to meet minimum standards. As you might recall, the European Commission used to present regular reports on the implementation of the EU-Turkey deal up until 2017, which had very limited, quite basic information on the number of returnees, the places where they were taken. These reports have stopped since 2017. So we actually have no public information from the Commission on what happens to people that are returned under the EU-Turkey deal, despite significant changes in circumstances on both the Greek and the Turkish side. A final aspect that relates more concretely to the new Pact on Migration and Asylum and the new round of legislative reform that we're embarking on is the codification of bad practice on the part of the European Commission. So when the suspension of access to asylum was ordered by the Greek authorities in March 2020, uproar included a number of actors, but not the European Union itself. The position taken by the European Commission, for instance, at the time, was much more tepid, let's say, in terms of the legal implications of suspending access to asylum, and very much encouraging when it comes to preventing people from entering Greece. This has become even more problematic with an initiative that was led by Greece in collaboration with Bulgaria and Cyprus to include in the Pact on Migration and Asylum provisions that would allow member states to derogate from key obligations in the asylum acquis when faced with situations of crisis. This seemed very much reminiscent of that Evros type of response and situation. And the Pact presented in September 2020 indeed includes the crisis regulation proposal, which foresees permissible derogations from a number of rules in situations of crisis and force majeure. What is quite interesting in that proposal, if you look at the explanatory memorandum, coupled also with the definition of crisis and force majeure in the recitals, is that force majeure is described and defined as an abnormal and unforeseeable circumstance that is beyond the control of member states. So a pandemic like COVID-19 would potentially qualify as such a situation. But the Commission in the explanatory memorandum frames the political crisis of the Evros 2020 events as force majeure. So it seems to suggest that we were faced with abnormal and unforeseeable circumstances outside member state control when Turkey decided to act on communications, announcements, and threats that were made quite consistently since 2016 to repudiate the EU-Turkey deal. This, I think, is definitely something for us to think about. The final, let's say, concluding aspect of all of this is that providing member states with a framework, even though a procedure with the Commission is introduced therein, to derogate from rules in those types of crises, and with a broad interpretation of crisis or force majeure to accommodate political consideration, could undoubtedly open up possibilities for arbitrary and very dangerous use of suspensions from asylum obligations. This includes delaying registration, it includes expanding border procedures, but these are likely to be things that are normalized and then accommodated with more complacency as we move along. I will leave it at that because I realize I've taken too much of your time already. You can find here in the latest slide selected resources both on the issues of pushbacks from different actors and on the suspension of access to asylum in Greece and the implications for the EU-Turkey deal. Thank you very much and looking forward to the questions.